Good morning. The Judiciary Committee will come to order. Pursuant to notice, I now call up H.R. 1865. Wait a minute. Without objection, the chair is authorized to declare a recess at any time. And pursuant to notice, I now call up H.R. 1865 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1865, to amend the Communications Act of 1934 to clarify that Section 230 of such act does not prohibit the enforcement against providers and users of interactive computer services of federal and state criminal and civil law relating to sexual exploitation of children or sex trafficking and for other purposes.
Without objection, the bill will be considered as read and open for amendment at any point. And the amendment in the nature of a substitute, which the members have before them, will be considered as read, considered as the original text for purposes of amendment, and open for amendment at any point. I now recognize myself for an opening statement. Today, I'm pleased the committee is considering H.R. 1865, the Allow States and Victims to Fight Online Sex Trafficking Act of 2017. This bill provides federal, state, and local prosecutors the tools needed to combat online sex trafficking. In the past few years, we've seen online sex trafficking continue to grow at an alarming rate. Despite great efforts by law enforcement, young children and women are being advertised online brazenly for sex trafficking. Furthermore, despite the fact prostitution is nearly universally illegal in the United States, online prostitution markets operate with virtual impunity. These markets provide an unregulated venue where sex trafficking flourishes. It is no secret that gangs and organized crime family members are using this platform to sell women and children like chattel to profit off of their misery over and over again. The websites providing these platforms, without any regard for the victims being sold on it, must be held accountable. Backpage.com is the most recognized name amongst these websites, and Backpage will certainly be held accountable. We know there is currently a federal grand jury convened in Arizona hearing evidence on Backpage. There are also numerous civil cases pending against Backpage, and while initially these claimants had been denied relief in the First Circuit, facts that came to light through a thorough congressional investigation have now placed these claimants in a strong position. But Congress cannot be tasked with investigating every website involved in operating these markets. We must ensure law enforcement has the tools to investigate and prosecute these websites so that these bad actor websites are punished criminally and victims receive restitution and to unearth facts which may be pled in civil suits. In crafting this legislation, we consulted with local prosecutors and also with the Department of Justice. There are significant difficulties in prosecuting websites like Backpage for knowing facilitation of sex trafficking, since these kinds of advertisements rarely, if ever, will say the person advertised is a victim of sex trafficking. A more effective approach in combating these websites is to charge them with the facilitation and promotion of prostitution. H.R. 1865 therefore makes it a crime to use an interstate facility with the intent to promote or facilitate prostitution. The connection between prostitution and human trafficking is undeniable. Studies show that countries with legalized prostitution are associated with higher human trafficking inflows than countries where prostitution is prohibited. A study from 2003 in the Journal of Trauma found that 89% of women involved in prostitution wanted to escape. Prostitution is inherently harmful and dehumanizing and fuels sex trafficking. Significantly, H.R. 1865 provides an enhanced punishment for websites that purposely promote prostitution in reckless disregard of the fact that people are being trafficked on their platforms. We also must ensure that local and state governments are able to use these tools, as many of the flourishing websites are regional. These websites are also too numerous to place these prosecutions solely in the hands of federal prosecutors. To that end, H.R. 1865 makes explicit that state criminal laws which punish the same conduct underlying this new federal crime may be enforced without running afoul of the Communications Decency Act. The bill also explicitly permits state criminal laws to be enforced which punish the same conduct underlying the federal sex trafficking statute in the event any local prosecutor may find it useful. Finally, the bill creates a new civil recovery provision under which victims may bring claims. Given that it may be difficult for victims to show that a website knowingly facilitated sex trafficking, this new provision tracks the elements of the new crime where a claimant would only have to show purposeful prostitution and that the website's reckless disregard in promoting prostitution contributed to the claimant's becoming a victim of sex trafficking. I commend Congresswoman Ann Wagner for introducing this bill and for her steadfast leadership in combating sex trafficking and protecting victims, and I urge my colleagues to support this important legislation. It's now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, I appreciate that you are bringing forward today legislation to address the scourge of human trafficking. I strongly support providing new mechanisms for federal and state prosecutors as well as victims to hold accountable perpetrators of online sex trafficking. I also recognize the need to balance these enforcement tools with respect for free speech under the First Amendment and protection from liability for truly innocent parties that operate in the Internet ecosystem. I am concerned, however, that the substitute proposal, no matter how well-intentioned, has not been fully vetted and that does not have sufficient support from the vast community of survivors and other advocates who have been pressing for legislation over the last several years to address this important issue. That is why I requested that our committee postpone consideration of this bill to allow for a more thorough review by the stakeholder community, many of whom have had little time to review the new text. Unfortunately, the expansive scope of Internet communication and the proliferation of devices that allow us to be connected online for many beneficial purposes also have expanded avenues for criminal victimization. As members heard during the recent hearing on this topic conducted by the Subcommittee on Crime, research indicates that 63% of human trafficking victims interviewed were advertised online. And of the over 9,000 cyber tip line reports that the National Center for Missing and Exploited Children receives each year, 81% relate to child sex trafficking online. In cracking down on this online criminal activity, we must be careful to distinguish between innocent intermediaries who merely operate platforms for hosting third-party content online from those who participate in the commission of crimes that are advertised on their platforms. Out of an appropriate respect for the First Amendment and based on the desire to safeguard the operation of the Internet, Congress has been cautious when attempting to set rules distinguishing the two. While it may be difficult to draw the line in the right place, particularly when we want to incentivize providers and online platforms to be more and not less actively engaged in preventing the posting of harmful content by sex traffickers, we cannot turn a blind eye to the appalling victimization that occurs every day, and we must find a way to do more than allowed under current law. The Senate Commerce Committee recently reported out bipartisan legislation that won support from a wide array of stakeholders, including survivors, law enforcement, state attorneys general, and tech companies. A number of organizations that represent victims of online sex trafficking have written to us to state that the revised Senate bill provides a greater voice to victims and better tools to state prosecutors to hold accountable those who engage in trafficking. They believe that the proposal we are considering today does not adequately provide relief for victims of trafficking, and they argue that it would continue to shield websites that facilitate trafficking from liability. They also have concerns that they were not properly consulted in the development of this proposal. In light of these concerns, I had hoped that we would take the time to fully compare and consider the merits of the different bills with input from all of the relevant stakeholders so that we could develop legislation that has broad support, particularly from the victims community, and also provides appropriate protection for civil liberties. I do appreciate your effort to advance this discussion, but for the foregoing reasons, I believe the bill we're considering today should be considered a contribution to the dialogue on this important issue and not the end of the process. Unless the legislation is further improved and vetted through the legislative process in the House and discussions with the Senate, I may not be able to support final passage into law. Thank you, and I yield back the balance of my time. Chairman, I ask unanimous consent to place in the record a letter from 31 survivors of traffickers and anti-trafficking organizations expressing opposition to the substitute.
Without objection, will be made a part of the record.
Chairman.
Thank you.
The chair now recognizes the chairman of the Subcommittee on Crime, Terrorism, Homeland Security, and Investigations, the gentleman from Wisconsin, Mr. Sensenbrenner, for his opening statement.
Mr. Chairman, the internet has been one of the greatest innovations in history. It has brought tremendous economic and social benefits to humankind. We can now accomplish nearly any transactions with just a few clicks of a mouse from the comfort of our own homes. It is undeniable that for all of us it has made life easier. Unfortunately, the internet has also made life easier for criminals, who can use the anonymity of the web to mask their illicit activities and avoid detection by law enforcement. This is especially true in the realm of sex trafficking, one of the most horrific and insidious crimes you can imagine.
I think we have an issue with the microphone. You might want to switch to that one.
Thank you. Thanks to a group of committed, passionate professionals and brave victims, the problem of sex trafficking on the internet is now receiving the attention it merits. We are all now well aware of the reprehensible and blatantly criminal conduct of the executives at Backpage.com. Because young victims have come forward to share their stories, we are aware of the harm caused by these types of websites, which are not only a venue for sex traffickers to sell young women, but also materially contribute to this illicit conduct. Backpage.com's conduct also sheds light on websites that are using the Communications Decency Act to shield themselves from liability for their illegal activities, which is something Congress never intended. For these reasons, I am pleased to be an original co-sponsor of H.R. 1865, the Fight Online Sex Trafficking Act, also known as FOSTA. As amended, this legislation will provide law enforcement additional tools to combat websites like Backpage. The bill creates a new federal statute criminalizing the use or operation of an interstate facility with the intent to promote or facilitate prostitution or sex trafficking. The bill specifically amends Section 230 of the Communications Decency Act to make sure that state and local prosecutors can enforce any state law if the conduct underlying the charge constitutes a violation of the new crime. In addition, the bill amends Section 230 to make sure that state and local prosecutors can enforce sex trafficking laws insofar as those charges would constitute a violation of federal sex trafficking laws. Finally, FOSTA will provide new mechanisms for financially compensating victims. Receiving compensation can serve as an acknowledgement of the victimhood and help victims on their road to recovery. I commend Ms. Wagner and the committee staff for their thoughtful approach to this issue. The legislation is a culmination of months of hard work and shows that we can take measures to prevent online sex trafficking without undermining the foundations of internet freedom. I urge my colleagues to support it and yield back.
Chair, thanks, gentlemen. Are there any amendments to H.R. 1865? A reporting quorum being present, the question is on the motion to report the bill H.R. 1865 as amended favorably to the House. Those in favor will say aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Without objection, members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 2595 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2595, to direct the Secretary of Homeland Security to provide for an option under the Secure Mail Initiative, under which a person to whom a document is sent under that initiative may elect to have the United States Postal Service use the hold for pickup service or the signature confirmation service in delivering the document and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. H.R. 2595, the Strengthening the Department of Homeland Security Secure Mail Initiative Act, directs the Secretary of Homeland Security to allow immigration benefits recipients to elect to pay a fee to have their immigration documents sent to them via U.S. mail through the hold for pickup or signature confirmation service. The bill is short, but will have a great impact on the lives of many foreign nationals seeking to play by the rules and legally live and work in the United States. Currently, immigration documents are delivered via priority mail through the U.S. Postal Service, and while delivery can be monitored through the use of a tracking number, there are numerous incidents of individuals not in fact receiving the document that the U.S. Postal Service notes as delivered. One obvious concern in such a case is that the document was intercepted by an unscrupulous individual who will attempt to fraudulently use it. Another concern is the cost and time it takes for the individual to reapply for the document, which at this point is typically the only recourse if a document has gone missing. The U.S. Citizenship and Immigration Service Ombudsman discussed this problem in its FY16 report, noting that delays in receipt of immigration documents can adversely affect the ability of individuals to work or prove lawful immigration status. H.R. 2595 imposes no cost to the U.S. taxpayer, since if an individual elects for his or her document to be delivered via hold for pickup or signature required, the immigrant must first pay a fee set by USCIS that covers the cost of such delivery, as well as any administrative costs for the agency. H.R. 2595 alone is not the sole remedy necessary to fix the issue of immigration documents not being delivered to the intended recipient. USCIS has noted that it is working to ensure that applicants or petitioners ensure their mailing addresses are up to date throughout the adjudication process. The USCIS Director, Cisna, has just announced that he will form a working group to address the problem and implement changes. I am pleased that he is taking this so seriously, and I look forward to working with him on this issue. This bill is one possible fix for the problem. This committee continues to work in its oversight capacity with USCIS to ensure that other remedies are put in place as well. H.R. 2595 is a good anti-fraud and good government measure, and I urge my colleagues to support it. This time it's my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, many immigration bills that come before our committee break along partisan lines. I am pleased that H.R. 2595, championed by Representative Jackie Speer, is not one of them. This is a practical, straightforward measure that will make delivery of U.S. Citizenship and Immigration Services documents more secure and more dependable. That is something that all of us can support. In fiscal year 2016, the U.S. Postal Service reported as undeliverable almost 60,000 USCIS documents. That is 60,000 too many. Compounding the problem, numerous other documents checked off by USCIS as delivered, in fact, got shipped to incorrect destinations. The end result is a host of green cards, work permits, and other sensitive documents getting returned to USCIS, or worse, passing into the wrong hands. The security implications of these misdeliveries are troubling. Last year, the DHS Office of Inspector General noted that in the previous 3 years, the number of green cards sent to wrong addresses grew consistently. Unscrupulous actors can and will exploit these unaccounted for documents. Making matters worse are the often devastating impacts of failed deliveries on the intended recipients. No less than the livelihoods of immigrants may depend on timely and secure receipt of immigration documents. When USCIS or Postal Service error causes non-receipt, non-citizens may face termination from their jobs, loss of legal status, and even the prospect of deportation. I recognize that misdeliveries sometimes result from the failure of applicants and petitioners to update CIS on address changes. And I appreciate the agency's ongoing efforts to minimize its own mailing errors, but more changes are needed. H.R. 2595 represents a key part of the solution. The bill requires USCIS to offer customers 2 optional document delivery services: signature confirmation and hold for pickup. The former obligates the Postal Service to get a signature from the intended recipient before handing off the document. The latter secures the parcel at the post office until the customer picks it up directly. Both options come at no cost to the agency. Customers themselves bear the extra shipping fees. And both options will enhance rates of successful delivery by building in safeguards against USCIS and Postal Service error. That means less fraud and fewer catastrophic consequences for hardworking, responsible non-citizens. I urge all of my colleagues to support this bipartisan legislation to reduce fraud and to improve the lives of immigrants. I yield back the balance of my time.
Thank you, Mr. Nadler. I'd now like to recognize the chairman of the Subcommittee on Immigration and Border Security, Mr. Labrador, for his opening statement.
Thank you, Mr. Chairman. I support H.R. 2595, the Strengthening the Department of Homeland Security Secure Mail Initiative Act, and thank the chairman for moving the bill through committee. The bill aims to prevent immigration documents mailed by U.S. Citizenship and Immigration Services, USCIS, from being delivered or otherwise obtained by an unintended recipient. Unfortunately, this is not an uncommon occurrence. In fact, I'm sure that my colleagues have all heard from individuals in their districts to whom this has happened. As the Department of Homeland Security Inspector General stated in November 2016 report regarding green card issuance, over the last 3 years, USCIS received over 200,000 reports from approved applicants about missing cards. And the IG went on to correctly note that such errors can result in approved applicants being unable to obtain benefits, maintain employment, or prove lawful immigration status. In the wrong hands, green cards may enable terrorists, criminals, and illegal aliens to remain in the United States and access immigrant benefits. Unfortunately, the previous administration seems to have done little to address the situation. Committee staff has had discussions with new leadership at USCIS with whom this issue is of grave concern, and I fully expect newly confirmed Director Cisna to direct his staff to come up with solutions. In the meantime, Representative Speer has introduced H.R. 2595, which directs the Secretary of Homeland Security to allow immigration benefits recipients to elect to pay a fee to have their immigration documents sent to them via U.S. mail through the Hold for Pickup or Signature Confirmation Service. It is a common sense piece of legislation that will not fully solve the problem, but will certainly help. I appreciate her work on this legislation and look forward to moving it on the House floor. I yield back the balance of my time.
Chair, thanks, gentlemen, and recognize the gentlewoman from California, the ranking member of the Subcommittee on Immigration and Border Security, Ms. Lofgren, for her opening statement.
Thank you, Mr. Chairman. Many years ago, there was a congressman from Arizona, Mo Udall, who made a famous statement. He said, "Everything has been said, but not everyone has said it." So I think the comments made already cover the bill. I would add simply this, that this is optional on the part of the person seeking the immigrant documents. It's a security measure. It's uncontroversial. I would like to thank Representative Speer for the bill, and I would like also to thank Jason Boyd, who has been a detailee over to the committee for this past year from the Department of Homeland Security. He is going back to the department on December 22nd. His service has been exemplary. This is his last hearing, so we thank you, Jason, for your service to the committee and for working on this bill. I recommend its passage and yield back.
Thank you, Ms. Lofgren. Are there any amendments to H.R. 2595? A reporting quorum being present, the question is on the motion to report the bill H.R. 2595 favorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no. The ayes have it. The bill is ordered reported favorably. Members will have 2 days to submit views. And without this concludes our business for today. Thanks to all our members for attending. The markup is adjourned. It's close. We've had some other short ones.